Now we will see winding up by tribunal. Okay. Section 271 says compulsory winding up by tribunal under its discretion in following circumstances. Okay. The tribunal can wind up compulsorily, but this winding up depends on the discretion of the tribunal. It can wind up in the following circumstances. What are the circumstances in which the tribunal can wind up the company, can end the company? Liability to pay debts. Section 271 clause A says if company is unable to pay its debts or unable to meet current demands, though solvent, or creditor for amount exceeding 1 lakh rupees not get his money within 21 days after due date. Okay, the debt should be really due. The debt should not be under dispute. In these conditions, the tribunal may order to wind up the company, or the company pass a special resolution for winding up. Okay, the company would be the company can be wound up by order of tribunal if a special resolution is passed by a company. Though though the tribunal is not bound, it is up to its discretion. Okay, if the company passes any special resolution for winding up, okay, it asks the tribunal to wind up the company. The company asks the tribunal to wind up the company. Okay, in that condition, the tribunal is not bound to that resolution. It is up to the discretion of the tribunal whether it wants to wind up or not, and he should consider that the winding up is in the public interest or not. Like, he may not exercise, okay, the tribunal may not exercise its power to wind up if opposed to public interest or company's interest. Okay, if the winding up is in opposition to public interest or company's interest, in that case the tribunal may not order the winding up. Okay, a company would prefer voluntary winding up, which is cheaper, less time consuming. Okay, the company can choose to prefer voluntary winding up, which is cheaper and which consumes less time. Then why the company will prefer special resolution? It prefers special resolution, winding up by special resolution, when the company is in bad financial position, or it is facing problems of income tax, sales tax defaults, or it is having protracted litigation with the creditors, or there has been prosecution by the registrar of companies, etc. In these situations, the company would prefer to wind up by special resolution instead of voluntary winding up. By special resolution, all these problems pass to the official liquidator and the company's burden is reduced. Therefore, it is choosing to wind up through special resolution. And in what condition the tribunal may order to wind up? When the company has acted against national interest, against the sovereignty, integrity or security of the state, or against friendly relations with foreign countries, or it is against public order, decency or morality. In these conditions, the tribunal may order to wind up. Or when the company becomes sick, it is a sick company, so in that condition more than 50% of secured creditors may demand by applying to tribunal. Okay, they may more than 50% of secured creditors, they may demand by applying to the tribunal that the company should be wound up. They will provide the evidence that the company has failed to offer security or compound it. Or the tribunal may wind up on the application of a registrar if the tribunal is of opinion that the affairs of the company have been conducted in fraudulent manner, or the purpose to form the company was fraudulent or unlawful, or the persons involved in formation of the company or in the management, they have been found guilty of fraud, misfeasance or misconduct. In these conditions also, the tribunal may order to wind up. And next is when the company defaults in filing financial statement with registrar. Okay, if the company defaults in filing financial statement with registrar, the tribunal may order to wind up that company. The financial statement or annual returns are for the preceding 5 consecutive years. or if the company has not commenced the business within 1 year of incorporation, or the company has suspended its business for whole year. Okay, in these conditions the tribunal may order the company to wind up. Winding up cannot be done, not wind up, if the company has ceased its business, suspended its business, or not commenced business due to some temporary or unavoidable reasons, or any valid reasons. In that case the tribunal will not order the winding up. And next is, if there is any just or equitable cause to wind up the company, in that condition also the tribunal can wind up. The tribunal has wide powers and complete discretion in this case to decide when the cause is just and equitable. In in this clause the powers are to be exercised with great care and circumspection. Okay, after taking great care and with the great care and after inspecting everything around the issue, then only the courts should say that it is just and equitable to wind up the company. What are the grounds for which it can be said that it is just and equitable to wind up the company? When there is complete deadlock in the management of the company. Okay, there is complete deadlock, the company cannot progress further, or the company has lost its substratum. What does it mean? When the subject matter for which company was formed has gone, or the company has failed to materialize its main object, or it is impossible to carry business except at loss, or the assets of the company are insufficient to meet the liabilities. This was how the company loses its substratum. Next ground is mismanagement and losses, or there is oppression of minority shareholders by majority shareholders, or the company was formed for fraudulent or illegal purposes, or the company or the private company is in essence a partnership. In reality it is a partnership, and due to which there is abuse of power or breach of good faith. There can be compulsory order when there is a voluntary winding up. In what conditions? During voluntary winding up there can be a compulsory order can be passed when voluntary winding up cannot be continued in the interest of the creditors or contributors due to the liquidator's incompetence, his failure to fulfill his statutory duties. In that condition the voluntary winding up will be turned into compulsory winding up. So this was winding up by tribunal. We have seen in what conditions, in what circumstances the tribunal may order to wind up the company. Okay, next video will be about liquidator, his powers. If you want the PDF for revision purposes, okay, you can revise these notes through the PDF. The download link can be found in description box or comment box. You can take it from there. In next video we will see liquidator.